expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in.
Judgment sprung, in and out, the verdict swung. Oouchie car watch, we've just begun. Oouchie car watch, we're on the scene. Truth's unraveling, what does it mean?
All right, good morning, Ms. Hayes. Ma'am, you're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On February 2nd, 2025, an officer was dispatched to bombshells in Harris County, Texas. The officer met with the complainant, and the complainant stated she tried to leave the establishment following an argument with the defendant and her girlfriend. The defendant grabbed her by the arm. A struggle ensued and was broken up by two off-duty officers working at the establishment. The off-duty officer stated they saw the defendant grab the complainant and they moved quickly to break up the altercation. Based upon the information, the officers attempted to arrest the defendant for assault, family violence, physical conduct. While being searched, incident to arrest, the defendant began pulling away from the officers and kicking to prevent being arrested. The defendant refused to enter the patrol car by standing on the step by the bar and yelling.
Did they file the assault or no? Did they file the assault or no?
They did not file. No, they did not file the assault, Judge.
Okay. Ms. Hayes, I'm going to find that there's probable cause to go forward with your case. They didn't file it. I mean, I'm not going to put any conditions on her case then, you know? I'm not putting any conditions on your bond. Just be careful. Don't pick up any new cases. Be good while you're out there. If you pick up a new case, start misbehaving, I'm going to put your bond. Would you like to apply for a court-appointed lawyer, ma'am?
Yes, do y'all have like?
So Deputy Miranda's going to give you an application for an appointed lawyer. I don't want to talk about the case, but you can tell the lawyer and the lawyer can, you know, talk with us if need be, okay? Please, ma'am. Are you Mr. Juan Neal? Mr. Neal, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 31st, 2025, officer observed a vehicle with an expired registration. Traffic stop was initiated. Upon contact, officer approached rear side passenger vehicle and asked defendant to roll the windows down due to the tint. Officer then approached passenger side and observed HOMJ emitting from the vehicle. A PC search conducted. Officer found a black bag containing a jar of marijuana inside on the passenger floorboard. Officer found a firearm under the front passenger seat.
So he's the passenger then, right? Or is he the driver?
Maybe it's the driver's on. Let me double check.
Is he a driver? Was he?
We're not gonna argue PC on this case if you want to find him PC. He was not the driver, he was the rear passenger seat. There's nothing in the DINs that really connects him to the gun.
Okay. All right, Mr. Neal. Careful who you hang out with, you know? You hang out with dogs, you get fleas. Just really, you got one life. Live it to the best you can, all right? I'm gonna find no probable cause. Just be careful, all right? Okay, just hang tight for me. Vic, who's this?
Reyes on page 15.
Got it. You are Adam Reyes. Mr. Reyes, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On January 23rd, 2025, law enforcement officer observed a black Silverado and a white Honda Accord at the 7800 block of State Highway 6 turning left at a high rate of speed. The law enforcement officer made a U-turn at intersection and followed both motor vehicles. having to travel approximately 66 miles an hour in 40-mile-an-hour zone. The officer observed motor vehicles to be side by side with the Honda flashing emergency lights. The law enforcement officer observed Honda turn off the lights. Both motor vehicles began to speed up again while driving side by side, and they ran a red light. The officer attempted to catch up with both motor vehicles, causing the officer to travel approximately 90 miles an hour in 40-mile-per-hour zone. The officer briefly lost sight and re-observed the Silverado as the motor vehicle continued traveling eastbound. Traffic stop was initiated. The officer made contact with defendant, driver, the sole occupant. The defendant stated when asked about high rate of speed, "No, I was on my way home with my friend Adam, and Adam was following me home." Co-defendant arrived claiming he was there to check on the welfare of the defendant. The co-defendant stated, "I was following them home, but I broke off because I wanted to get something to eat." Defendant ID'd with a Texas driver's license.
And Mr. Reyes, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to participate in this type of activity again. If I find that you do, I'm going to put you in jail and then I'm going to take your ability to drive away. Do you understand? Can you look to see if he has a valid Texas driver license, please?
Yes, Judge, eligible.
Do you have the ability to hire a lawyer, Mr. Reyes, or did you want to apply for an appointed lawyer?
I'll hire one.
I'm going to have you sign a receipt, Victoria. I'll have you take a seat in the jury box while we get your bond conditions, while we sign it, and after that, you'll be free to go. Be safe in my city. Do you understand? All right. You are Ricky Thornton. Mr. Thornton, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, the complaining witness and the defendant are in a dating relationship. And on December 18th, 2024, in Harris County, Texas, officers were dispatched to an assault call at a hospital. The officer arrived and made contact with the complaining witness, who stated that she and the defendant are in a dating relationship. The complaining witness stated that earlier in the day, she and the defendant were in an argument due to the complaining witness telling the defendant that he needed to leave the location. When the complaining witness got up to leave, the defendant pushed her through a wall, causing her to crash through the wall, causing pain. The officer observed the complaining witness to have a laceration over her right eyelid, swelling and bruising.
It's a problem in this case. You know, the case is dismissed. Something went wrong. Something's wrong. I'm showing that the case is dismissed. When it shouldn't be.
This is Thornton, Judge.
Yeah.
My suggestion yesterday.
Or is it? I don't know. I don't even,
Dismissal that was signed
It is a DVD case,
for
Judge.
Mr. Witness.
I don't even see a knowing.
For Thornton, it's not published, Judge.
Judge.
I mean, ready to publish.
Judge, you said he spoke with Chief Campbell, dismissed for missing witness due to.
So it is dismissed then, right? Okay, your case has been dismissed, believe it or not. Just be careful out there, you know? Just, today's your lucky day. Count it, all right? Okay, man, good luck.
And let my client sort things out with those other jurisdictions as well as ours.
Your Honor, because of the fact that he has now 3 fugitive cases in our court, 2 out of Knox County, Tennessee, and now a new one out of North Carolina County, would be asking for no bond.
I told him beforehand, we've visited this issue before, and I told him the last time that he was here that I wasn't going to give him one. He just got way too much baggage. And it's all the same thing where it's a theft from an elderly, and we have the same thing that's occurring over and over and over. You know, and it scares me that if we let him out, is he going to pick up a 5th case, you know? Or it's so much baggage. He scares me, you know?
Oh,
And
He does have, he's kind of been a resident of this area, you know, for 25 years. So,
I get it, but he's got a lot. He's hopscotching with the states as far as criminality, right? He's got 2 cases in North Carolina, or 2 in Tennessee, 1 in North Carolina. Now he has 1 here. He's got, in 3 different states, he's got charges. It's too much. And I think that because of that, he's a big flight risk, and I don't want to lose him. You know, and he knows this because I've told him this before. You're not the first person that has approached on me with this, you
understand, Your
know?
Honor.
So, yeah, it's just, you got to understand that there's a lot that comes with this, right? If it was one, perhaps, right? But you've got three in three different states. It's way too much. You know, at some point, it's got to stop. Now's that time. So, the idea is that has he made bond? He hasn't made bond on the cases upstairs, right? So because you have not made bond, the 14 days here that would normally kick in is told if and until that hold upstairs is released. So if you're able to make bond on that theft case upstairs, that would kick in the 14 days for those states to come get you. And then they would have to battle it out as to who comes and whatnot, and, you know, so I guess just let me know what you guys want to do. The felony court is set for March 11th. Typically what we do is we just set it the day after. And I'm sorry, Mr. You know, but it's just too much. Yeah.
Your Honor, I do also want to add, he hasn't waived on this new North Carolina case, so he wants to start that clock today.
And I'll let you guys see if that's something that you want to do. You know, if not, we can go ahead and get a governor's warrant. That'll take 90 days. But, you know, if you post bond on the case upstairs, that would get the ball rolling really, really quick.
Right.
So, okay. You guys let me know what you'd like to do. Thanks. Coming up, counsel.
Morning, Your Honor.
Okay, who do you have?
Mr. Kabir, for the bond violation.
Okay, come up, Mr. Kabir.
As per hearing, the
Yes, yes, absolutely.
This position said you should consider.
All right, quiet in the courtroom. We're going on the record. Ready, Ramona?
Yes, ma'am.
All right. We are on the record. Today's date is February 7th, 2025. It is approximately 10:35 in the morning. We're here on a Faizan Noor Kabir, cause number 215-8240. Guys, would you announce yourselves for the purpose of the record? State.
For the state, Kelsey Seabrooke, for the state, Mackenzie Walton.
State defense.
for the defense, Andrew Salinas, Salinas.
All right. And we are here now due to Mr. Kabir having a bond violation. This is our third bond violation report that we have had. Our first bond violation. So I guess let me start up. Mr. Kabir is charged with driving while intoxicated. He was ordered as a condition of his bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. State, does he have a DWI open elsewhere to refresh my memory, please? Mr. Salinas, did he not have a DWI?
He currently, yes, Your Honor,
He has an open DWI where?
in Navarro County.
So we put conditions on him. I can't. Please, Felicia,
The most recent ones, Judge, or there's been a few that we've amended over time.
what are the current conditions now?
The current conditions now are. Appear in court every time the case is set on docket, no new law violations. Install a IID device in the vehicle, no driving without permission of the court, no drugs, no alcohol. Applying to obtain a scram device, and to submit to drug and alcohol testing at the court's discretion.
Did he have a curfew as well?
No, Judge.
He originally had a curfew, Your Honor, but because there were no issues with that, we had it removed.
Okay.
Yes.
And so now our first bond violation report that we had was September 23rd, 2024. And in that one, he had been in lockout for failure, I guess, to pay. I don't know, which is weird because we normally always pay for all of them. A second bond violation report was filed January 6th, 2025. Where I guess he was in lockout again because due to no recalibration of the device. And we now, February 4th, 2025, have a third bond violation. And in this violation, the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device has reported one consumption event. that occurred on January 16th of 2025 at 11:55 PM. It was also confirmed by a Scram analyst as well. Correct?
Yes, Judge.
Okay, so.
Yes, Your Honor. So,
Yes.
yes, so to begin with the first amended order for pretrial, so if the state wants a copy, I have a copy to show them, but sure. So, Your Honor, just going to the very first order, as Your Honor just noted, usually agency fees are waived for that. However, the box on that for saying that the fees were waived, I believe were not checked on that. Further, Your Honor, the main purpose here for your determination of giving someone bond in the first place is to establish that they come back to court. So are they a flight risk? And then also, are they a danger to the community? Now, Your Honor, if an interlock device is in lockout on a vehicle, it doesn't start. No one's driving that vehicle specifically. There's no way that they can. I can call a witness to testify that, but I know that you
But that doesn't
are aware of
excuse you
that.
from violating the conditions.
Your Honor,
Are you justifying that because of that, you can just?
No, Your Honor, I'm trying to contextualize this because we've been here two prior settings before. I know you've concerned greatly about the number that it's at number 3 now. I'm trying to establish that the first and second, there was no indication of alcohol consumption or drug use during that time.
It wasn't working. How are we supposed to know?
And Your Honor, again, one of the two main points of determining what kind of bond both the conditions and amount are, will they return to court and community safety? Here, my client who's being accused of DWI wasn't driving that vehicle. So it was impossible for him to be driving that vehicle, Your Honor. So I ask you to take that into account as far as public safety goes. As far as this latest bond violation, it's the state's burden to prove that my client violated his bond. All we have right now is a report by Scram, but no one is here to testify on behalf of. Well, we can call that, Your Honor, but
Yeah.
sure.
Judge, I spoke with the defense counsel today and he said that he was not requesting to have anybody come here to testify to the Scram device.
We have Fleischer that can be called up as a witness to testify as to what happened and whether he tested positive or not, whether he's consuming alcohol.
It's also the state's burden to prove that he did that. So that's, yeah.
Please.
Yes, Your Honor, we would call retrial services, Ms. Felicia Charles.
Okay, ma'am, would you please come up, raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
So you have first amended order and then second, third amended pretrial supervisions and then the fourth. So referencing the fourth amended order for pretrial supervision and bond conditions, what I'm showing you, do you recognize this?
Yes.
Can you tell us what this is and what are the conditions that are checked?
These are,
Sorry, could you repeat what you just said?
sorry, I said, I don't know if she needs that. It was an extra paper.
Okay, I just want it on the record.
Sorry.
That's all right.
Yes, these are pretrial bond conditions, and these are listed as appear in court every time the case is set on docket unless the judge waives appearance. No new law violations, install ignition interlock within the vehicle, no driving without permission of the court, no drugs, no alcohol, and then to obtain. We do have a curfew of 9 PM to 6 AM, and then a Scram device to be installed.
And so what we're showing you is what's been marked as State's Exhibit 1, and we'll tender this to defense for any objections.
No objections.
Admitted as one.
So in this case regarding the Scram device, can you tell us about that?
Yes, so what exactly about?
What is that? What's the standard procedure someone's supposed to do?
Yeah, so a scram device is ordered and it tracks the, press.
Objection, Your Honor. The foundation, I believe the state is trying to ask her to testify as far as are you trying to establish her as like an expert on scram?
And then I was not trying to establish her as an expert, just from her experience, what the scrum device is basically for, which she can testify to as a trial.
I'd ask that the court consider that as, that testimony as a layperson, not as for the purposes of establishing expertise.
So I want to know whether there is a violation for alcohol consumption. So, what day do we have any kind of hot blows? What's the amount? Do you have anything of that nature?
Yes, so the report should have been provided to the bond violation email as well of the graph.
And I'm showing her now what's marked as states.
For the exact amounts and everything, I would need to look at the report that was provided in the email.
Okay, please.
Have the graphs been printed, state, or she's just referring? Yeah, just so we can all agree on what she's referring to.
And I'm showing you what we marked as states exhibit 6. Can you please tell us what this is?
So this is a scram report sent back to us whenever the device information and data is pulled. And this is what the analysts observe for either tampers or consumption. And this is what they send us back if there is a confirmed tamper or consumption as per.
Okay, so this fairly accurately depicts a scram for United States.
Yes,
We will tender defense for any objections and know that this has been, is it correct to say this has been emailed to defense prior to this date?
yes.
Defense received it, no objection, Your Honor.
Okay, it'll be admitted.
Okay, so can you tell us about the specific dates in this report again that was given to defense prior to today of the basic dates that the scram was not completed properly?
Yes, so the device seems to be fully functioning. And on January 17th, sorry, Friday, January 17th, the scram device picked up a peak TAC of 0.078%. And then established a zero baseline once again for the dissipation rates of the alcohol at 9:05 a.m. on January 17th.
Say it again.
9:05 a.m. January 17th, 0% TAC was reestablished for the dissipation of alcohol.
Okay, and for those dates, the ones that match on what I'm showing you as states exhibit 2, the bond violation report, can you please, do you recognize this?
Yes.
Can you please read the details of the violations here?
It says the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device has reported one consumption event. The confirmed alcohol consumption occurred on January 16, 2025 at 11:55 p.m. This information was received on 1/17/2025 and confirmed by a scram analyst.
Thank you. We pass the witness.
Okay.
All right. Good morning. I just want to, if you could turn to, I believe it was it's Exhibit 3, I think, for the Scram non-compliance report, the cover page. Do you see that? Yeah, what she has right there. Oh, is it 6? Okay, would you stay, since you're close, would you give that to her? Thank you. So just looking at the cover page there, can you read who the agent is on this report?
Justice Turner.
Are you Justice Turner?
Yeah.
Have you consulted with Ms. Turner about this report?
Through the emails, yes, for the bond violation report and the.
What exactly did those conversations include?
The entire.
So
thread that was provided.
let me, sorry, that was a poorly phrased question.
I'm
Withdrawn.
sorry, I
No,
don't
that's,
understand.
that's my fault. Don't worry about it. My question is, did she consult with you when compiling this report?
Would you be more specific?
Did you help in the assembly of this report?
No,
Okay. Have you ever assisted or aided in the assembly of a Scram systems non-compliance report?
no, no one.
No, no one in the department does. Okay. And do you have any sort of, have you ever worked for Scram systems?
No.
Have you ever had any special training in Scram systems?
Yes.
What is that training?
I actually met with Ronald Grant from Sentinel, the regional representative, about maybe 2 months ago
Mhm.
to get an advanced knowledge of this device. This is one of the very few devices that I do have advanced knowledge in, but
And
not expertise.
Sure. And what exactly did this person teach you?
We went
Briefly.
through how to read the graph, kind of how to establish consumption versus a tamper,
Mhm.
environmental factors versus
Mhm.
consumption, et cetera.
Okay. So during that training, did you ever actually look at a physical device, the Scram device?
No.
So you didn't do any like live experiments where, like, for instance, you put on a Scram and then, drank alcohol to see how that works?
No.
No, okay. And as far as Mr. Kabir's Scram device, have you examined it prior to this hearing?
Me personally, no.
Okay. And one second. So is it fair to say that you've been thoroughly trained on the theory of Scram device and alcohol detection? Is that fair to say? That let me rephrase that. So you don't have any actual technical experience with how the Scram device detects alcohol in someone's skin. Is that fair to say?
Think?
I don't want you to think. It's a yes or no.
I still don't understand.
I'm trying to understand too.
Do I not understand how a Scram device works, or have I not for myself and?
Sure. So, this is pretty, is it fair to say like the science is kind of advanced here? Like when you received your training, did you have the personal opinion that was advanced science that you were learning about?
I believe so.
Okay. And you don't, so basically it sounds like your training, and correct me if I'm wrong here, your training was mostly so you could be able to make sense of what a report says and not necessarily how the actual device itself works. Is that fair to say?
Partially, yes.
Okay. What's what am I
We
partially
did go
wrong about?
over, yes, reading the graphs, but then also what kind of would entail, what would mess with the device.
Okay.
Essentially as well with tampers, environmental factors with that, makeup
Mhm.
or, placing something between the skin, how things are
Mhm.
worked around with the device, how people evade from, having the correct reading on the device.
Sure. And so that's, you basically learned that all in theory, right? There were no like, withdraw that question. So I'm just saying there was no like actual, you didn't look at any studies. Did you read any studies when you did this? Okay.
I actually met with him due to another case. I wanted to further understand it, so we examined
Good.
the report for that.
Well,
And also reviewed some of the peer-reviewed articles.
Well, that's great. I'm glad that you want to, a lot of people won't. They'll just kind of do their jobs, right? I'm glad that you want a further knowledge, but what I'm trying to get at is it's fair to say that knowing how something works in theory and actually examining the actual thing itself, the practicality of it is different, right? Do you agree with that statement?
Yes.
Okay, so without actually having examined in your own personal observation, how a scram device detects alcohol in someone's system, it seems that, is this fair to say that you're very, very well versed on theory, which is probably more than some other people, but not necessarily on the practicality of detection?
Objection asked and answered.
Okay, just, let's go.
All right. Just ask the question. I don't know if that was an objection or sustained
I mean,
or overruled.
let's just move on. I mean, we're here to see, is there a positive blow or not? She's
All right,
testifying that
it's
there
the-
was.
Sure. I'm just saying that this, all right, I'll make my argument in closing. I don't have any further questions. Thank you.
Okay, closing, or wait, hold on. Anything further from the witness?
Two very quick questions, Your Honor. So do you get notifications if the scram device has been tampered with?
Yes, we get notified of tampers and consumption events.
And you get notifications if it's been cut off? Like, just what's been going on with the scram device? You get those notifications?
Yes.
Okay, thank you. No further questions.
Matt?
No further questions, Your Honor.
Thank you so much. Okay, argument.
So, Your Honor, this is a pretty basic, simple case. The bond violation report is evidence the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device was reported on one consumption event. This happened January 16th of this year at 11:55 p.m. And this information was received on January 17th of this year at 5:18 a.m. And clearly, there were up to 4 amended orders for pretrial supervision and bond conditions. It was obvious which the defendant was supposed to do, and he directly violated the order, was evident by the pretrial services and bond violation report. So it's pretty clear here that we would be asking to revoke bonds in this case.
And we would just like to urge that this is a fair and convincing standard, as I already know, Judge, and it's not beyond a reasonable doubt. I don't think that we need a scientist here to prove that the scram device is a device that can be detected.
Okay.
Yeah, Your Honor, I agree with state insofar as this is a simple matter. Where we disagree is, I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The state did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that is, at least for right now, is supposed to have been prepared by someone else who is not here to testify. There's no ability to cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the state failed to prove their burden of proof that my client consumed alcohol. And I would ask that, Your Honor, again, not revoke the bond, keep it as is. My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court. And in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just take into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. And with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are used.
Say it again.
These devices are used all the time.
Well, their use all the time
Just
is
so-
irrelevant to needing an expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you.
We have the positive THC or stuff.
He had a positive THC, right?
Yeah,
As well?
that we sent him earlier this week.
He also tested positive for
THC.
marijuana as well.
Well, Your Honor,
Here
that,
this week.
that wasn't, are we still on the record then on that? Okay. Well, I would also want someone to come testify about that, Your Honor, but you know, that I'll make, I know, but I know you already made your ruling, but I was ready to testify on that because they don't have anything on chain of custody on the test itself on whether it tests cannabinoids, which Delta 8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any delta whatever. Regardless, it's number 3, goes with you. Off the record. Sorry. Thank you. But I just can't, with an open DWI and a third, that's it. I can't just keep doing it, you know? At some point, I become an enabler and I can't do that. I can't keep doing it, you know? So.
Well, I mean, Your Honor, I understand you're revoked the bond. Would you consider raising it to?
Well, I am going to raise it, right? I'm going to raise it to 7503 now.
Well, and look, I'll just, if you could take this into account, Your Honor. This is a hired client. You know, he has every intention of taking this case to trial. So I would, you know, just, I'm not Chief, Your Honor. So if you could keep that into consideration on that.
It's, you know, and it's
I understand.
representing him in Navarro too.
No, I'm in touch with his counsel there, but no, I'm not representing him there.
Okay.
Yeah.
But tell him this, that he's lucky that it didn't revoke him on the first 2 cases, considering that he has an open, you know, really, because, and I'm telling you now, I don't know how I didn't, but I can't just keep doing it. I can't.
75.
7503. Yeah. Lori.
Sean Benjamin Webb. He's in custody. He is charged, I forget what he's charged with, but he picked up, this is a new offense and I have to,
So Webb is the last name?
Bernard Webb.
Oh, right.
But he's in custody.
Yeah. I remember we were talking about it yesterday. So the deal is this, is that, they gave him a PR bond on the first case?
I'm not sure, this is Ariel's case.
So we have him on the 12/19, he picks up a terrorist threat and assault a police officer. 2 weeks later, a false report to a police officer, and now he's picked up a less than a gram case. So the only thing I was gonna do is just revoke on the first case and then
Okay.
leave. They didn't give him a bond on the first case, so he's got
Okay,
$100 bond on that one. I'm just gonna revoke and set the other one at, 5,004. and
Okay.
That's it. Okay,
thank you.
thanks.
This is Trajan Edwin Judge.
Okay.
Trajan, I'm sorry.
Good morning, Mr. Edwards.
Edwin.
Oh, Edwin, I'm sorry. I'm my fault.
Or, sorry, reset the mayor. Yes, because of.
All right, so Mr. Edwin, you're charged with evading arrest or detention. And criminal trespass. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 21 days in jail on the evading credit for 7. Is this what you want to do, sir?
That I'm getting out tonight.
Yeah, it's time, sir.
So time serves is very sexual to me. Thank you so much for it.
But you need to understand, this is going to go on your record. If you run from the police again, they can charge you with a felony offense. Do you understand? You-
If our Salveria toll license does not want me to get in trouble like this again.
I didn't hear.
Salveria toll licenses does not want me to be acquitted in being in a judge face like this again.
He's saying somebody doesn't want him and to get in trouble again like this.
You know what we're doing today, right?
Today is the lawyer's offense of licensing me to get out of jail, yes, sir.
Well, you're pleading guilty. Is that how you understand it?
I'm not necessarily pleading not guilty, yes, sir.
Are you guilty?
I am fully registered to be guilty.
What happens if you pick up another evading arrest?
You are resourceful and knowing to not do it. So we don't
What do you
want.
say?
He said, we are resourceful to knowing to not do it.
Okay, don't. You can get a felony next time. Do you understand? All right. You're giving up a lot of rights by doing this today. You don't want a trial. You don't want to talk to witnesses. You need to understand that there are consequences. It will go on your record. It will be there forever.
Just be like Salveria toll licensors. Just be like I am the CEO of Salveria toll licensors, which means I am a lawyer.
Let's,
To understand that. I do
let me
not wanna
reset
get in
it,
trouble.
Judge.
We do not want to get in trouble.
Let's go back.
You're saying we do not want to get in trouble.
I want to make sure you understand, Mr. Edwin.
We're gonna try again, Judge.
Sounds like he was itching to get out, but I want to make sure that he, hey,
That's a quick question.
sure, of course.
Remind me of violations from this case.
Engaging in the like kind of behavior. And then, no driving as well, because she has a prior DWI. She's on bond for DWI and then she picked up this one. So,
Thank you.
thanks.
Okay, got it. Perfect. Thank you.
Mr. Edwin, we just need to make sure you understand what's going on. Okay? You know that you're pleading guilty to this offense.
Yes, sir.
Yes, sir.
Do you know what that means?
Taking convictions.
Right. So you know that this charge will go on your record, correct? If you run from the cops again, you'll be facing a felony charge. You understand that? Okay. You also need to understand that by pleading guilty, you are giving up many rights. You don't want to go to trial. You don't want to talk to witnesses. You don't want to confront, cross-examine the people who are accusing you of this offense. You give up the right to appeal. Once you plead guilty, you can never change this. Do you understand? One more thing is that if you're not a citizen, they can deport you, exclude you from the country, or deny naturalization. Once you plead guilty, you can never change it. Do you understand? Okay, how do you plead to the offense of evading arrest or detention? I will find you guilty. I'm going to follow the agreement. Be careful. Don't run from police again. Okay? All right.
Good luck to you, Mr. Edwin.
Look, Mr. Edwin.
You're getting out today. Thank you, Judge.
Thank you, Warren.
Watch, we're on the scene. Truths unravel, and what does it mean? In the halls where stories clash, Oouchie court watch quick as a flash.